prevailing party clause. Very, very, very important for a contract. I consider it a must have. I don't know if other attorneys would, but I definitely would. And why is that? When you go to court or you go to arbitration or you go anywhere that you want to settle a dispute, the common misconception is that, well, I win, so now you have to pay my legal fees, you have to pay all my court costs, you have to pay everything that I incurred, all the expenses I incurred to be able to get to this point where I won. That's the common misconception, is that the other person has to pay. Not unless you have it in your contract. Now, the Florida statute talks about very, very, very limited circumstances in which that's sort of a given. And there's certain litigation devices where that can be done. But the first thing that you look at is, does it say in the contract that you have to pay my legal fees if I win? Does it say that the prevailing party gets their legal fees paid by the non-prevailing party, basically the winners and the losers of the case? If it doesn't say that, then you're going to have a hard time convincing the other party to pay your fees, right? So it's a misconception. All the time I ask my clients, I said, who do you think pays if you win? And they go, yeah, the other party pays, of course.
Yeah.
And I go, no, not unless I put it in this contract. Do you want me to put it in the contract? Yes, of course. So what I do is I include collection costs, because that's also a cost. So even if you win and you have to collect money from the other person or the other company, there's a cost for that, because you might have to garnish their wages, their bank accounts. You might have to sell their assets to be able to satisfy that judgment. There's still another step. There's still costs associated with that. Okay. And as a prevailing party, the person who won the lawsuit, you don't necessarily want to pay for that. So I almost always, unless my clients tell me otherwise, I almost always put a prevailing party clause in there so that we at least have it in the contract where I can tell the other party, look, you're breaching this contract and you are so wrong that when I prove that you're wrong, not only will you have to pay for your breaching of the contract, but you now have to pay all my legal fees. And according to the contract, it says that. And I've done that before for a lot of my demand letters. And that alone is like, oh man, on top of paying what I breached, now I have to pay all the legal fees, their legal fees, my legal fees. No. So it's a good way to make sure that, if you're in the right. Now, if my client is in the wrong, I'm like, no, let's not. Let's just figure out a way to settle this. But, it's good to have that, to make sure that is a protectionary kind of thing where you make sure that if you're winning, that you also have your fees paid. And it's not automatic. It's not done just because. The Florida statute is very, very limited on what they consider that to be. The content on Minding Your Business is for informational and educational purposes only and should not be construed as specific legal advice. This show discusses general legal issues affecting business owners. Opinions of the guests are not necessarily that of the show. If you need assistance with your specific legal issue, please consult with a licensed attorney.